So the purpose of this webinar is focusing in on the Motor Insurance Bureau and their schemes under the Untraced and Uninsured Drivers Agreements. So I'm going to go through exactly what they are, what they cover, and then look at a couple of, or 4 case studies in particular to explain how we've dealt with cases under both schemes. So for those of you that have obviously logged into the previous webinars, you'll know who we are, what we do. For those of you who haven't, our kind of USP, as it were, is that we are all cyclists. So we understand the vulnerability that our clients feel being out on 2 wheels, but we also understand the importance that cycling plays in our clients' lives and how quickly they want to return to it after being involved in an incident. So all our claims focus around getting them back on their bike, making sure we get interim payments for them, things like that, and also focusing in on rehabilitation. So that plays a slightly different role under the Motor Insurance Bureau agreements. So I'll go through how that is different to a normal motor insurance claim. As well as looking after clients once they've been involved in an incident, we also do some safety campaigns. At the bottom here, we've got our Light Up campaign. And we are looking at ways constantly to reduce the number of incidents on the road and how we can play our part in that. In respect of what we do, as many of you will know for having listened to the previous webinars, and obviously if you're your former clients as well, what we focus on is the civil law and the law of negligence. So we've got to prove on balance of probability that someone has been negligent and caused our client injury and loss as a result of that negligence. We're not particularly interested in the criminal law and innocent till proven guilty, anything like that, or proving beyond reasonable doubt. We're not really interested in that, but in the motor insurance uninsured claims, the criminal law does play a part because we need to show that someone didn't have insurance at the time, which is obviously a legal issue, and there will be criminal prosecution as a result of that. But we don't really get tied into it. We just need to make sure that the police have followed through down that route. The same applies here as does in any case. We all owe each other a duty of care. And where that duty of care has been breached and injury has resulted, then a claim can be made. Sadly, it's not the men in black that we have to deal with, and Will Smith. That would make my job far more interesting on a day-to-day basis. The Motor Insurance Bureau are set up, is funded by other insurance companies. So if any of you are car drivers or motorcycle riders, things like that, then you pay insurance. And part of that insurance goes towards the MIB to fund their organization. The reason for that is to make sure that there is equality, because at the end of the day, if you're involved in an incident with an untraced or uninsured driver, you shouldn't be penalized by comparison to someone who is hit by someone who is insured. What the MIB cover is people that ought to have been insured under a compulsory insurance policy. So we're looking at motorized vehicles here. This webinar is not looking at cycle-on-cycle collisions or cycling and pedestrian incidents. We are looking at incidents involving motorized vehicles that were uninsured at the time of the incident, or the vehicle is untraced because they've left the scene, or in some instances, we're looking at kind of diesel spills, shed loads, things like that. The most typical MIB cases that we tend to deal with are your uninsured vehicle or driver, your untraced vehicle or driver. We have the odd diesel spill cases involving cyclists, and obviously hit and run incidents as well. The difficulty you have in claiming in terms of negligence, we need to be able to say, this is the person that caused the negligence. So we need to be able to say what vehicle they were driving at the time, and also who the driver was. So we have had a case, for instance, where it was effectively a hit and run, but our client was able to note down some of the registration number plus make and model of the vehicle. From that, the police were able to find this vehicle, and they were able to speak to the owner of that vehicle, who admitted under caution that they were the driver at or around the time of the incident involving this particular client. On that basis, we raised a court action against the motor insurance company that covered the vehicle at the time. And throughout the claim, they said, it's not us, you've got the wrong party, it's not us. We ended up having to speak with intelligence within the police to work out how many other vehicles this could possibly have been. And through that investigation, we found out the likelihood is this was the vehicle. And if the driver said under caution she was the driver at or around the time, we also had the correct driver. That particular case proceeded all the way to a court hearing. And astonishingly, as far as I'm concerned, and certainly as far as the advocate involved in the case was concerned, the sheriff in that case said, yep, you've got the right vehicle, but you've got the wrong driver. And therefore our case failed because we were unable to say who the driver was at the material time. This is despite the fact under caution, she said she would have been the driver at the time. She said she was not involved in any incident and the sheriff chose to believe her, which is the law that we work in accordance with. So in that particular case, what we had to do is go back to the Motor Insurance Bureau and say, we effectively have an untraced driver's claim here because we do not know who the driver was at the time. We have a sheriff saying, you've got the wrong driver, and she's not telling us anyone else that would have been driving at the time. We've not sued anyone else. So the Motor Insurance Bureau had to pay out to our client under the untraced driver's agreement in that instance. So it's not always as straightforward as things might seem. And regardless of what investigation is carried out, the Motor Insurance Bureau are sometimes that safety net that we need to go back to in order to, that our clients will get the compensation that they deserve. In terms of some case studies, I'll go on to particular ones involving untraced and uninsured agreements. But at the very beginning, clients will come to us and say, it might well be that adrenaline's running high, as it would be after an incident. There might be some kind of altercation with the driver, and therefore they don't get the details. They don't have the registration number, which is the key part that we need in order to proceed with a claim against the actual insurance company. So if we don't have that, effectively it's an untraced claim. And we complete a form via a portal system, which is submitted to the MIB, and they then investigate it. So for those of you who have been listening in on previous webinars, what normally happens is we will intimate a claim to a motor insurance, a motor insurance company, and they have to investigate liability, but we'll carry out our own investigations. We will also get our client medically examined, we'll value the claim, and then submit all of that to the insurance company and then negotiate settlement, or if we need to, raise a court action. With the Motor Insurance Bureau, they do the investigation side of things. So while we'll work away and make sure we have everything we need, they're the ones that will gather the medical records. They'll instruct a medical expert to see our clients, and then they will make an offer, which we can then look at the evidence and decide whether or not it's reasonable. There are kind of two reasons for this. So under the untraced driver's agreement case, there is nobody for us to sue other than the MIB. So we have no right to a court action. Our only way of trying to get compensation for our client is through the Motor Insurance Bureau route. And therefore they take a hold of the situation and make sure that they know what is being spent in respect of outlays. In respect of the uninsured cases, what happens there is, in theory, our clients have a right to claim against the driver. But 99% of the time, if the driver's not got insurance, they also don't have assets that would allow them to pay out to our client if in the event of a successful claim against them. And therefore, a right to relief against that individual is going to be limited to none. So the best route is going to be through the MIB. But what the MIB will do, once they've paid out to our client, is they will go against the driver themselves and reclaim what they can by way of outlays, by way of compensation that was paid to our client. So they deal with all of that, and therefore they still want control of how much is being spent on a case. The only time that changes is if we have a particularly complex injury case, or there are difficulties with someone returning to work, something like that. We will go to the MIB and say, we're taking hold of this situation. This needs a specialist solicitor to look at. We need to be able to dictate to experts what it is we need a view on. We need to find out a bit more about rehabilitation. We need to know whether this person has capacity to ever return to employment. And therefore we want to take full control. But for us to do that, we have to dictate to them who we're instructing in respective experts and roughly what those costs are going to be. The MIB are not quick at taking action with anything, and they're not quick to respond. So what I will always do is put a time frame. I will say, I am instructing X expert. If you don't return to me in 7 days, I'll assume you're quite content with that, knowing full well they can't return to me in 7 days, because the likelihood is they won't have even read my correspondence in 7 days. But I've put the time frame on it. I've told them what I'm going to do, and I proceed on because it's in the interest of my client to do that. If, of course, there's a problem further on down the line, they can tell me what that issue is. But it's certainly in my experience dealing with these cases, the MIB have turned around and said, you're entitled to do that, and you've done it for the best interest of your clients. They've not had a problem with it. The MIB system means that they do take longer to do everything. So under the normal protocol agreement we have with insurance companies, they have, for instance, 12 weeks to investigate liability. The MIB could take up to 6 months, could take 12 months. It all depends how quickly information gets filtered to them and how quickly they review that information. So normally the handlers, they might go into each case once a month. And if things happen between those reviews, it won't necessarily be picked up and dealt with. And that's why you do need a specialist solicitor to deal with these claims for you. We will bug the MIB every week if we have to. We need to know what they're doing, when they're doing it, have the medical report, do they have the police report, what's happening, what's the time frame we're looking at, to make sure things keep ticking on, because otherwise they will just sit back and they'll wait till the next review. So that's our job as well, is we're constantly working out what they're doing at what stage. But we also need to know what that agreement says. And that leads me nicely into the first case study involving a previous client of mine who was involved in an incident near Meadowbank Stadium. So the client is cycling towards us in this image, and the vehicle involved is effectively doing the same maneuver as we can see the taxi here. It's turning up into the side road. There's a collision as a result because the driver fails to give way to the cyclist, but unfortunately, the driver just proceeds up the road and leaves the scene. Police were called to the incident, but despite investigations, could not trace that vehicle. So we had to deal with a claim under the Untraced Driver's Agreement. This particular client had relatively minor injuries, but he was on an expensive bike and all his kit had been damaged as well. So he was more concerned about that, as are the majority of our clients. So under the Untraced Driver's Agreement pre-2016, you could not claim for property damage unless the person that was claiming had died or had been an inpatient in hospital for 3 days or more. So if they'd been seen in A&E, then went home, they had no right to claim for property damage. The caveat I should say to that is the MIB will only deal with injury cases. So if it's property only, they expect you to go down other routes. So to go through, for instance, if it's car on car, your own motor insurance company, or if it's your bike, maybe your home and contents insurance, etc. They will only deal if there is a personal injury claim. So in this instance, we were potentially looking at about £1,500 for the injury, but then about £1,500 to £2,000 for the bike and the kit. So there was a huge gap if we could not claim for the property damage. Initially, the MIB came back and said, well, we're not sure you can claim for property damage here. It's an untraced driver's agreement. But in 2016, they amended it to say that you could also claim for property damage if the claimant, so the person pursuing the claim, had 3 or more outpatient appointments. But they did not specify in their agreement what that meant. So it was open to interpretation. And us lawyers love anything that's open to interpretation because we interpret it to suit us. So when we looked at this, we saw that the client was referred to physiotherapy and in fact attended 4 physiotherapy sessions. So there was a backward and forward conversation dialogue with the MIB saying, look, your agreement was changed. You said that there's 3 or more outpatient appointments. The client's attended physiotherapy. He can claim full property damage here. They were then saying, well, where is the referral to physio? We don't see that. As I mentioned previously, they request all the records. So we didn't have those records to hand. We just had the medical report that they had instructed. So I had to ask for all the medical records to be sent. I then highlighted all the sections I was referring to, sent it back and said, there's your proof. now pay out. And in the end, the client was then able to get money for his injuries and the money for his bike and kit, which meant that he was fully compensated for the incident. But the importance is any changes to this agreement, we need to know what those changes are and how they impact our clients, because there is no guarantee that the Motor Insurance Bureau and the people that work for them will necessarily know it themselves. The second case here is involving a segregated cycle route in the Glasgow area. And unfortunately, we have these types of incidents in Edinburgh as well, and I imagine elsewhere in Scotland, where people get dirt bikes and off they go down cycle tracks to usually avoid the police. And that is exactly what happened here. It was an incident involving a dirt bike, uninsured, and they'd collided with our client. The problem was that the police were involved, but there was quite a long process of tracing the people involved, tracing the person who knocked our client off, and whether or not this was proceeding under the untraced or uninsured driver's agreement. The Motor Insurance Bureau were getting a little bit agitated because they were saying, well, it wasn't on a road, it's a dirt bike, we need to check what the process is. And we were saying, well, at the end of the day, that dirt bike should have been insured, and it wasn't insured. So it should be an uninsured claim rather than an untraced claim. But the information needed to be filtered through from Police Scotland, through from the Procurator Fiscal, to show that this, the person involved had been charged in connection with obviously the incident, and also with the fact that they were uninsured at the time. But it took a whole year from intimating that claim to the Motor Insurance Bureau saying, yes, we'll deal with it under the uninsured agreement rather than untraced. And the differences really come from how they sometimes value the pain and suffering element. It shouldn't make a difference, but we do tend to see that there are higher awards in uninsured claims than untraced claims. And that stems back to what I'd said about the fact that the MIB can go against the individual and reclaim some of that money. So they tend to be slightly more generous in those cases. And obviously all property damage was included as well. But there's also a fee element in terms of what we do. We get paid differently if it's an untraced or uninsured claim as well. So the MIB were very clear they needed to determine whether it was going down the uninsured route or untraced route before they would settle matters. If a claim is proceeding down the uninsured route, in theory, we have a right of recourse to the courts, and we can raise a court action against the individual that caused the harm, but bring the Motor Insurance Bureau in as what we call party minuter. So they'll then deal with the action, and then at the conclusion of the claim, so once the sheriff determines that the motorcyclist or car driver is at fault, then the MIB will pick up the tab. So the way that the cases are dealt with are different, and they therefore have to be quite distinct. And that's why it took a while for the MIB to determine whether this claim was going down the untraced or uninsured route. The next case I've got here is actually one that's ongoing at the moment, and it's quite interesting because it comes down to the intricacies of who is insured. Is it the vehicle? Is it the person? Is it both? And how the police play their part in this as well. So a client of mine was involved in a collision where a driver went through a red light, knocked my client off his bike, police attended the scene. The vehicle at the time was uninsured, but the driver assured the police that she was insured and therefore her insurance company would cover it. The driver was charged in connection with the incident and careless driving, but was not charged in connection with insurance. When we got the police report in and we intimated the claim to her insurance company, they turned around and said, we did not insure her to drive this vehicle. It was a courtesy vehicle, and therefore you'll need to speak with the garage to find out who covered her at the material time. It transpired the garage gave the car to her without any discussion as to if she was insured or otherwise. So she was effectively driving the car uninsured. There was a lot of backwards and forwards with Police Scotland here. She pled guilty to the careless driving charge, but she has now subsequently been charged with failure to insure her vehicle because although she was insured, she wasn't insured to drive that car. And therefore this case now has to proceed through the Motor Insurance Bureau under their uninsured driver's agreement. Had it been that the car was insured, but somebody who wasn't insured to drive that vehicle was driving it, then interestingly, the insurance company would have to have dealt with it under what we say is RTA insurers. So if the vehicle is insured, but the driver is not, then it can go through the insurance company. But if the vehicle is uninsured and the driver does not have insurance to cover the car they're driving at that time, it becomes an MIB case. So there are intricacies involved here. And what sometimes appears straightforward, we've got a driver going through a red light and her being charged, becomes slightly more convoluted in their process. And we need information from Police Scotland, we need information from insurance companies who potentially could have been involved in order to show the MIB that this is in fact an uninsured driver's case. The fourth case study here involves a diesel spill case. So diesel spill cases tend to be there's more of them in the motorcycling side of things rather than the cycling cases. This case actually came to us after another solicitor's firm turned this case down. So the image at the bottom there is the diesel spill at the material time, and our client was effectively crossing over the dipped curb, crossing over the roundabout when she came into contact with this contaminant and came off her bike and sustained quite significant injury as a result. In order to claim through the untraced driver's agreement for a diesel spill case, you really need images or eyewitnesses that can say how substantial this spill was, because the agreement says it has to be a substantial spill. And we also need to try and show that it would have come from a single vehicle and it's not been a buildup of contaminants over time. This proceeded through the MIB untraced route, and the MIB turned the case down when the previous solicitor was involved. The client then came to us and said, I don't know what to do, but I'd like a second opinion here. Looking at those images, it was clear this is a substantial spill. And it also didn't appear to me, as a layperson in that respect, that it was a buildup of contaminants. It looked like it was a single spill that had been deposited on the road. I obviously had to get an expert to verify that was the case, and they did agree that it was most likely a single spill rather than a buildup of contaminants. So on that basis, we decided to appeal the MIB decision. And there is, the whole appeal system is set out through their agreement. I don't intend to go into too much detail about that here because it's quite a long process, and there are various stops along the way, but it is entirely different to a litigation process. What happens once we appeal the case is it goes to an arbitrator who is effectively an advocate, or is an advocate, that has been assigned to deal with Motor Insurance Bureau work. And they look at all the evidence. But you need to appeal it on particular points. So in this case, we said the MIB were wrong to turn it down on the basis of this being a buildup of contaminants, because it was clear that it was a single spill. And the arbitrator agreed with us, but said at the material time, this road was closed. There was a huge amount of roadworks going on nearby, and they were using this road to effectively park up machinery and vehicles. So the arbiter said, I think you can probably trace who deposited this because the road was closed, and therefore only certain people would have had access. So he sent us away to do that. And effectively what we had to do is raise a court action against 4 different parties, which included local authorities, contractors, etc. And we got as far as a court hearing on the merits of the case, where the sheriff determined that because it was a closed road, the contractor at the time did not have a duty of care to our client. So it now goes back to the Motor Insurance Bureau to deal with, and they will then have to pay out as a result of it through that process. So diesel spill cases, you can claim if it's a substantial spill and we can prove it was one single spill rather than a buildup of contaminants. But the MIB will still say, look, if you can find someone that deposited this, then go against them, don't come to us. In terms of police involvement, this is really key in the MIB cases. So you must report the incident to the police, whether it's going through the uninsured or untraced driver's agreement. It has to have been reported to the police within 14 days of that incident. And it's very helpful if we can get the police reference number and note that on the form when we submit your case to the MIB. If it is not referred to the police within 14 days, your case against the MIB can fail on that basis and on that basis alone. They will simply look at it and say, well, if you didn't report it to the police, then we're not investigating it. The main reason behind that is obviously under the untraced route is there CCTV or a witness appeal that could have then found that driver, and after 2 weeks you've lost the ability to be able to do that because most CCTV is wiped after 7 days. Or under the uninsured route, the likelihood is the police would be involved so that the MIB can show, we can show the MIB that that driver was uninsured at the material time. So that is key in dealing with the MIB cases. In respect of what we're doing, it's exactly the same as with any case. We're trying to restore the injured party to the situation which would have prevailed had no injury been sustained. And that's what the MIB are there to deal with as well. They deal with it in the same way as insurance companies. They need to look at what the injuries are and how they can then compensate someone for the injury sustained. They do not deal with the rehab side of things in the same manner. So it comes down to us showing what private rehabilitation someone needs and then getting funding for that. They won't look at rehab companies in the same way that insurance companies will. They also are a little bit less willing to provide interim payments. So depending how long a case is going on and depending how kind of forthright we can be with them, there's no guarantee you'll get interim payments in an MIB case. So again, it just comes down to managing clients' expectations and saying it might be a straightforward case in respect to the MIB, but it could still take them months to make any payment to you. So if you've got access to repair your bike, replace it, then it's best to go down that route and then we can recover the money at the end of your case. In respect of what to do if this ever happens to anyone listening to this, and I certainly hope it does not, but it's always good just to have the knowledge and understand what you can do. So obviously, if you are ever involved in an incident and it's a hit and run type incident where the third parties fled the scene, call the police to the scene of the incident. If you have been injured, they should still be attending. If there's anyone around that witnessed the incident, then get their information as well, get witness details. Take any photos you can. If there are photos to be taken, like diesel spill cases, for instance, it's important to get photos of that. If you're able to get a third party reg in a case that would then potentially be an uninsured case, do get that, get the details of the driver as well. And then obviously if you need to contact us, we can give you advice. We're always here to give free advice. If you're not too sure whether there is a claim there, whether there's not, give us a call and we can talk you through it. We can talk you through what we might be able to do, whether it's an MIB case or otherwise. The difficulty sometimes when I'm talking about being able to identify the driver, your close past type cases are kind of the most common ones there, where you might be able to get the registration number as the vehicle passes you, but you might not be able to determine who the driver was. And if someone is not admitting to being the driver at the time, that can sometimes cause some issues that the MIB then need to be involved. But that's for us to give you that advice and say, look, we have an insurance company in the background, but if there's going to be any difficulty here, let's get the Motor Insurance Bureau involved early on. They'll sit in the background throughout, but if the case fails against the insurance company, the MIB will pick up the tab. So that means the injured party is never then lost out in money as a result, because the compensation will still be paid out. So that's really the MIB in a nutshell. But obviously any questions, or if you want me to go into detail about anything further, then I think you can pop a question in the Q&A. You guys probably know how this works far better than I do, or I'm sure Rod can tell me if people have questions. So,
no, I should have mentioned at the beginning that people should ask using the Q&A. I noticed actually that Andrea's commented to us, asked a question. If you are very seriously injured and unable to report the incident within 14 days, what happens? What can you do then?
Well, if of course we're looking at, for instance, someone's in a coma in hospital for that time, the likelihood is the police would have attended. If it's a serious incident like that, as soon as the ambulance came to collect from the scene, the likelihood is they would have contacted the police. So although you haven't logged it with the police, there's a strong chance if you've got that type of injury that they would have appeared at the scene anyway.
Great. Any other questions at all out there? I noticed Joseph's got his hand up. I don't know whether that's been up there for a while. Joseph, are you wanting to say something or ask? I can allow you to talk if you wish. you might have had it up, hand up earlier.
It was actually right at the beginning.
Oh, was it? Sorry,
it was. Yeah, just sorry about that.
No, it's all right. No problem. That's fine. That's right. Well, a question come in here. It's about road bullying against cyclists. When a driver passes very close to you, causing possible loss and balance, can we report that? Well, we have cases, of course, which we've dealt with, which you can perhaps talk about those.
Yes, so obviously if that's effectively a close pass is the way that we tend to distinguish them. But yes, there's the close pass initiative with Police Scotland. So if you are involved in that type of incident, if you fall off as a result of someone passing too closely, then absolutely you have a potential claim there. If you don't fall off and it's just as you've mentioned, they're bullying, then by all means get the registration and then you can report it to police with time, date and location. They can then in turn speak with that driver. But absolutely, if you fall off your bike as a result, then that is negligence because they have not given you as much space as they ought to have done, as is stated in the highway code, and therefore they've been negligent in doing that.
I don't know whether he was also maybe inferring that there might be some kind of malicious intent in relation to that activity. I guess that's a criminal offence potentially, but you'd have to be able to demonstrate that, I guess.
Yes, intent is always difficult because we don't know necessarily the intention of others unless they're saying something as well. But yes, unless there's evidence that you can then provide to the police, that becomes slightly more difficult. The civil claim would be a far more straightforward route than the criminal side of things.
There is actually, I'm bring it up here, but there is a plan at the moment to try and see if we can get a operation for a portal for logging video type evidence. Isn't that something that the Cycling Scotland is trying to push through? Yeah,
so certainly the police divisions down south seem to have been far better at setting up the portal system where you can upload helmet mounted footage, things like that. And then there's people that go through that footage and can then contact the drivers involved or the owners of the vehicles involved. Police Scotland have been a little bit slow in the uptake of this, and also depends kind of who it's reported to, how quickly it's dealt with, if it's dealt with, etc. So yes, there are a number of agencies now supporting that this needs to be looked at, and it needs to be looked at urgently, because anyone listening to this, if you're cycling regularly, and sadly you will have been involved in a near miss / close pass at some stage, if not every time you're out on your bike, sadly.
Okay. One other question's come in from Farzane here. If you're a cyclist and you hit a car which was parked in a bus stop, which they shouldn't have been parked in, what happens in that case?
There's no straightforward answer to that. It all depends where the bus stop is, how visible that car was. There is case law in respect of cyclists or even car drivers hitting stationary vehicles that have parked in places they ought not to have parked. The kind of most obvious and straightforward claim would be someone parked in a blind bend, for instance, where the visibility was low to none and you've collided with them. If there is good visibility and you ought to have seen that vehicle, then it is going to be an uphill struggle of a case. Just because the vehicle should not have been parked there is not sufficient to say that they have been negligent and ought to pay you out in compensation. So it all rides on the merits of what exactly happened. As I say, if this is a bus stop that is around a corner, you've come around the corner and you've not had time to react to something, then potentially there's a claim. But the counter argument to that is if it's a bus stop, you would also need to be aware if there was a bus, for instance, stopped there. So how much you're paying attention to your surroundings as well. So there's no straightforward answer. It just comes down to the merits of what the actual circumstances are. So if something's happened to you, then let us know and we can see if there is anything to be done there.
Great, brilliant, thanks very much. Any further questions? If we've got no further questions, I'd perhaps just like to wind things up and thank Jodi Gordon very much indeed for a real good trot through the MIB. I learned a lot myself in relation to how we handle those cases, so that's brilliant. Thanks, Jodi, and thanks everybody again for joining us this evening. Have a good evening and perhaps look forward to seeing you next week.